I mean, this person's gone. So they're so vulnerable to exploitation. If there's anybody you can rip off somebody who's dead, because they can't say that they didn't say something. They can't say they didn't do something. So the courts thankfully came to the rescue, and they came to the rescue in this elaborate ritual that's called the execution of a estate planning document, of a will.
Welcome to Life's Third Act, an enlightening look at estate planning, retirement, and beyond.
So we're back with part 2 of our episode on Jerry Garcia. Part 1, we talked about mainly his life, his early life, the Grateful Dead generally. And now in this part, we want to talk about end of life as well as the issues relating to his estate. Lots of stuff.
The good stuff and the bad stuff.
Yeah, not surprising. Lots of interesting stuff with Jerry Garcia's estate. So join us as we get into this episode. Yeah, I'm showing that he is having 4 daughters, and one may be adopted.
No, there was actually another young lady at the time that her name is Sunshine Casey. Ken Kesey and Carolyn Adams Garcia, their daughter, but he was with her, and so she became kind of like a stepdaughter to him, and she has claimed that she considered Garcia her dad, her father figure, until she was 6 years old.
And what's her first name?
Her first name is Sunshine.
Well, yeah, I'm showing that the 4 daughters that he acknowledged in his will were Heather, Annabelle, Teresa, and Keelan.
Mm-hmm. So this was just like a girl that was kind of a stepdaughter-ish.
Yeah. Okay. So then Jerry Garcia, he goes into a drug treatment facility. He dies not entirely unexpectedly. There was a will in place. Apparently the will was of somewhat recent vintage, considering the fact that he's only been married for a year, to Koons, Koons. And in that will, it's a simple will. He gives 1/3 of the estate to his widow, which is Deborah Koons. He gives 2/3, that's divided in a little bit of a complicated way, not really. 1/5 each to the 4 daughters, so that's 4/5 go to his 4 daughters, Heather, Annabelle, Teresa, and Keelan. And then that remaining 1/5 is divided in half, so it's 1/10 to Sunshine, and then another 1/10 to his brother, Cliff Garcia. Was Cliff, I wonder if that's his older brother.
Yeah, that's his older brother.
Okay. Part of the problem with this estate was that it was a simple will when it could have been much better, but I'll talk more about that in a few minutes. He dies in 95. The estate's opened. He names as his executor his wife, his current wife, which is Koons. The estate's opened, and it's not ultimately resolved for another 9 years. So into the next century, like 2003, 2004 was when they wrapped up the estate. And one of the reasons that the estate went on that long was that there was lots of conflict, lots of claims to deal with. Shortly after his death, whenever you do publication, somebody dies, there's a window of time during which a creditor has to come forward. And those of you who watch this show know that the probate process is intended mainly to accomplish 2 things. It's to determine who is it that has a claim, and they get paid first. If you have a legitimate claim that people owe you money, well, if they die, you can assert that claim in the probate case, and then you'll get your money before relatives or whoever he left his estate to in a will or whatever the other instrument might be. The other function, though, is to determine who did this person want their stuff to go to. And so if there's a will and the will's valid, then it goes to those people. If there's not a will, then the state has rules that will dictate where things go. So those are kind of the twin purposes of opening probate estate. So there's this window of time once there's publication published. And in most states, you can have any legal periodical will do. So it can be like a legal newspaper where people in positions of authority regularly scan those things, whether it's businesses, banks, et cetera, and it will get notice to the world maybe not as quickly as the New York Times front page, but it will get news to the world that you've died, and if people have a claim, they need to come forward. From the time, that'll normally be required to be published for about 3 weeks in a row, some states 4 weeks in a row, maybe some a few more. So it's not just one ad that runs, it runs repeatedly. And then once that's done, once that last ad runs, then the clock starts for a period of time during which any claim has to be submitted or it's barred. So if there's proper notice given, which is what I just described, it has to be done properly. But if you dot your I's and cross your T's, then at the end of this period of time, call it, in many states it's 6 months. Some states it'll end up being 7th month because there's an additional month tagged on for the turnover in notice, et cetera. So if you do that correctly and a claimant doesn't step forward and says, hey, I'm owed money, then they're barred. So in this case, the notice was given. Unfortunately, a lot of people did come forward, and they came forward in the window of opportunity. And it turns out that $50 million was claimed. Now, the size of the estate, this is always a murky thing when we're doing this show because most of it's going to relate to the intellectual property of famous people, the name, image, likeness, any contracts that they've signed to endorse certain things, et cetera, that may already be in place. So in this case, the early estimates were $9 million. That was up to around $15 million. Mm-hmm. So none of us, despite the fame and the respect that many of us have for Jerry Garcia, the performer, we're not shocked to hear he didn't have a lot of assets when he died. I mean, we'd have been shocked if he did have a lot of assets, because one thing that wasn't very important to him was material things. That was clearly not something that he worried a lot about. And somebody like that, you can imagine, is likely to not give any more attention to their estate planning than they did to the planning during their life of their financial affairs. And Jerry, money and planning of his finances was not important. So those same problems made their way that existed in his life, especially the latter part of his life.
But I will say, I thought it was interesting that he did have a comic book collection.
Yeah.
So I was like, he collected comics. So that's a different side of him. Yeah.
Well, yeah, I would. I find that more believable than something like 18th century literature.
Yeah. Nope.
So he ends up with a kind of a messy financial life before he died, and that's what really produced this situation after he died, where there were things that were unresolved, and then they had to be resolved by somebody, and it became the responsibility of those who were managing his estate. Now, he named as his executor, of course, Coons, his wife. Now, that means that that's a profitable position depending on the size of the estate. Now, this is in California, so I don't know all the rules. I certainly don't know all the rules of California. I don't practice there personally. But I can say that it's typical that person, their compensation will be dictated by a statute that allows them a certain percent, and that will correlate to the amount of effort too. So it's not simply a percentage where it's a mess and somebody has to do a lot of work, then the court would expect to pay them more. So there is some elasticity there in what the actual amount's going to be based upon the particularities of that case. And in this case, I think that Coons ended up getting, 1 year, I think she got $250,000. I think all of this added up to over $1 million or so as she was paid as an executor. Not a bad compensation. Although I will say, she did a lot of work. Mm-hmm. And I mean, it was a lot of work, and she's allowed to hire lawyers as she must.
Yeah, and she had to.
Yeah, and so that was appropriate. But still, it's not as if she could subcontract all this out and she had no responsibilities. She did, and it was no easy task nor pleasant task for that many years and that much contention. Now, the main contention, oddly enough, I mean, the single biggest item related to this potential $5 million that he would have paid to Mountain Girl, her name Carolyn Adams, I think. She was the second wife.
Yes. The one that he was married to the longest.
Yeah, and they were in the middle of a divorce at the time that he signs a contract. And this is just a few years before. Remember, he's only been married to the wife at his death for about a year. So there was a divorce that was pending. It was ugly. There was arguments over money and accusations being made. And of course, Jerry doesn't like conflict. And I think that he wanted out and he didn't care much how he got out. We don't know the exact story, but there's this piece of paper. I'm not even using the word document, but it is a piece of paper that's 13 lines long in which he says that he will pay $250,000 a year up to $5 million
over the next 20 years.
Yeah. So it'd be spread out, but it would come to a total of like $5 million. And it wasn't written as long as he lives. It was instead written in such a way to where when he died and it was submitted to the estate, it would seem to be a claim that would continue to exist irrespective of his death. Like normally maintenance, if this were regarded as a maintenance agreement, then there's lots of precedence for saying that you can't be ordered to support somebody after you're dead. Same thing goes for children too. But in this case, this was an independent contract he entered into voluntarily with her. And yet another benefit of it was that it did relate to divorce. It's interesting to note that if this had anything to do with his estate, and this became an argument to try to overcome this document, if this had anything to do with estate planning, if it was a promise to give her something when he dies, if he says, yeah, as part of my estate, you're with me a long time, I promise to give you $5 million for my estate, that sort of thing, that clearly is a violation of the will statute. The will statute is this sacred thing that has produced what is famously an elaborate procedural thing in order to prepare a will, where you have two witnesses in the room. In some states, they have to be witnessing each other. There has to be notarization. In some states, there has to be an oral recitation to the people in the room. I'm making this my last will and testament. So all this ritual we associate with doing a will, that's really a product of the will statute that goes literally back to 1500 something. Henry VIII's reign in the 1500s. He died in 1548 or something. So it's been around a long time. But let me defend this archaic tradition. Is that, I mean, this person's gone. So they're so vulnerable to exploitation. If there's anybody you can rip off, you can rip off somebody who's dead, because they can't say that they didn't say something. They can't say they didn't do something. So the courts thankfully came to the rescue, and they came to the rescue in this elaborate ritual that's called the execution of a estate planning document, of a will. So, and it's just wills, it's not trusts that have to be executed in this way. So I'm telling you all this to say that had this been worded differently, this document would have been DOA. There would have been no chance that it would have been upheld. It would have been clearly a violation of this ritual, these rules regarding a valid will, because it would purport to do something a will does. It doesn't have to call itself a will. It would be purporting to do something that a will does. So in this case, it didn't do that. So and it was attacked as that, naturally. If you have a good lawyer representing the estate, you want to definitely allege, no, she's trying to come in through the back door for a claim on the estate. But no, this was pretty clearly stated. It was a settlement of the divorce. So this document survived. I'm telling you this may be consolation to some of you who may have made any promises to somebody in writing regarding your will. But in this case, this was a difficult claim to contend with, and there were accusations that Jerry didn't realize what he was signing. There were applications of duress. There were lots of things that were very credibly alleged to say this isn't a valid, this piece of paper, and Jerry doesn't know what he's signing, which that's easy to believe.
Well, what state was he in? Was he on anything at the time?
Yeah, and it was a long trial. I mean, this went to trial, and somebody got on the stand, a roadie got on the stand and said, well, look, all I know is Jerry told me that, look, I want to, divorce is driving me nuts. It's unpleasant. He says, I just want to get it over with.
Yeah.
And so you had a testimony by his daughters, who, of course, the daughters were supporting the validity of the will, and this didn't so much go to the validity of the will, but it would take a chunk before it got to the beneficiaries of the will. Because remember, the person coming here is a creditor, and generally creditors are the opponents of the beneficiaries of the will because they have contrary interests. Now, you could have a creditor, in this case you did, who said, they're a beneficiary also, and they're saying, yeah, but I'll get more money as a creditor and I want money. One of his daughters had a claim. I won't get into that.
Yeah, that was the child support.
Yeah, a child support issue. But so you can have a beneficiary who decides to also be a creditor because it'll get them a larger portion of the estate. But in this case, a long trial, it ended up, the judge said, he said, look, he says, it seems to me that this is a valid document made in settlement of a divorce, and that, though Jerry may not have liked signing it, whatnot, he knew what he was doing, and and the judge indicated he was going to hold it valid. So the judge at that time did not issue what his opinion was going to be as to what the exact amount was owed. So it ended up being settled. The amount that was ordered was 1.5.
Yes.
So, I mean, not bad. So she gets 1.5 million.
Yeah, out of the 5 she wanted.
Yeah.
Or that was on the paper.
I assume she got some of the 250,000 for the years before that, for the 3 years or so. So anyway, that was a chunk. Another issue that is a recurrent thing with Jerry is it's not clear with the band what the rules are as to who owns what. And none of us are surprised to hear this. This was not locked down with precision the way with many bands I'm sure it has been. So the equipment normally belongs to the band because the band buys the equipment. Apparently the band paid for Jerry's guitars. Yes. It depends on what evidence you believe. But there was this famous luthier, and this luthier's name is Doug Irwin, and he was just a master artist, and he created what, it's not exaggeration to say, is one of the top famous 5 guitars in the world.
Yes.
Maybe 6 or 7 guitars in the world. One would be Lucille, B.B. King's. So there are a handful of these really famous guitars. Well, anybody who knows anything about guitar or about rock music will know of the Wolf. The Wolf was a guitar that was played by Jerry Garcia for almost a decade in the early years, many years, and thereafter, but in the early years especially. And then later there was another guitar made by Irwin called the Tiger. And they both, they're easily identifiable by this figure that's carved into each of them on the face of the guitar and in the body of the guitar, and one is a wolf and one's a tiger. So they're very cool, though, the designs. It's sad because this luthier, a luthier is a guitar maker. This luthier, he, a very talented craftsman, the best, but, life management issues and whatnot, he ended up homeless. So despite his talent, and he is getting older. Yeah. So he is older and homeless. And so to him, when Jerry Garcia put in his will that he was leaving 4 of his guitars, and I guess the other 2 also came from Irwin, but I'm not sure about that. But anyway, these 2, Wolf and Tiger, were among those 4, and he wanted him to go to this guy because it was a gesture. But Jerry, again, not being mindful of the details of ownership, he makes this gift, and of course the band asserts a claim. They're claiming that these cannot be given in the will because they're not owned by him. So if you put something in the will that you're transferring it and you don't own it at the time, then it's void. And in this case, that became the subject of litigation. And ultimately, what a judge ruled was that 2 of Tiger and Wolf went to Doug Irwin, to his credit. And they ended up selling for $1 million apiece.
Which is good because that got him off the streets.
Yeah, it did.
Yes.
They sold for approximately $1 million apiece, 900-something thousand and whatnot. So that was $2 million and went to him, sold at auction. Mm-hmm. And Jerry wanted him to have that money, I know. Yeah. So the other 2 guitars apparently went to the band. Anyway, so you had conflicts with the band itself, and it wasn't just over guitars. Master recordings, those which were in storage, and these recordings had not been digitized. So think of, thousands of hours of stuff that needed to be properly handled in order to ultimately be preserved for the public. There were disagreements about that and who had authority over those. So there was conflict between the family and the band relating to that. And it held up some of what was done. I suspect that what might have been, I'm guessing, I don't know this to be true, I'm guessing that it might have been called Grateful Dead on the road, but it came Dead and Company later. I read that where Bob Weir said that that's because out of respect for Jerry, and that may be true. But I think also they were having conflicts with the family, and the family would have had some say over the use of that name.
Yeah, it's probably better to just cut ties.
Yeah. So I think that it even impacted that. I know it impacted what was released for years after. That maybe less so today, but for years after, it was a big issue in the release process. So now here's what's impressive, though. Despite all these conflicts and all these lawsuits, and some were legitimate, some were not, and a lot were not, in fairness.
There's probably quite a list that was just thrown out of court.
Yeah,
like, no.
And it could be that Jerry was certainly a victim of people who took advantage of him. I guarantee you his whole career, people probably took advantage of him to a great degree. He was a perfectionist in some ways, but if it wasn't on that very short list of things that he really, really, really cared about, and then he didn't care about them at all. So, and I think in this case, it's good that a lot of those claims were held invalid or unenforceable. And you can't say the executor gets all the credit. Of course, she had professionals, but she did, acting as executor, she got this reduced to, believe it or not, $700,000 from $50 million. So, so this estate, and let me come back also to the question about, original estimate was $9.7 million. Later it was thought, I think that now if you read the official number that was decided by the time it was closed out, the estate was $15 million. But as we've said with other artists in the past, over the next 30, 40, 50 years, it's going to be worth a lot more than that.
Oh, yes, because we constantly are moving forward when it comes to technology and how you can reuse that music, his voice, his image. So many things are possible.
Yeah, and he was such, as you said, a character. He's somebody who is not easily forgotten. He wasn't simply a good musician. If he were simply a good musician, then yeah, he may fade fast, because there have been a lot of those very, very talented people, but they come and they go, and they're a little more forgettable than that extremely eccentric, unique persona that he projected and became a cult figure. I mean, a cult figure across much of the planet.
Well, and like we were talking earlier, I mean, he's so much loved that, Ben and Jerry named an ice cream flavor after him, and it's one of their most popular flavors. So.
And the estate is still getting money from that.
Yes.
So
well, and you think about it, everything old becomes new again, and we've seen a lot of things from the 80s and 90s make a comeback. I would not be surprised if those ties of his made a comeback as well. It wouldn't surprise me at all.
No.
And more money coming in that way, too, with his artwork.
So he was a special human being. Definitely. In a lot of different ways. And I think that he will continue to generate money directly and indirectly, directly through some of the things he's done, like his artwork and whatnot, but indirectly just through Grateful Dead. And the family, there's been some conflict in the family. So they formed an entity called the Jerry Garcia Estate, LLC. And that was in existence for a 5-year period of time when they turned over management. They agreed on a third-party manager to handle all these issues related to capitalizing on these rights, these royalties, and name, image, likeness, endorsements, et cetera. So that was a 5-year period of time. It expired, and then things kind of came apart. They didn't renew that relationship. So the group splintered a little bit. I think that Coons originally participated with the 4 daughters, with the Jerry Garcia Family LLC. They originally participated with that, but then when it came apart, and I think it was 2006, then the children kind of went their own way to manage their shares, and then their mother's managing, or the surviving spouse manages her shares separately. So The good news is that lots of good decisions have been made regarding how to take these recordings and to refresh them, to digitize them, to bring them onto the market. They do have professionals representing them, which you must today. We've talked a lot about that.
Yes, that's
But
definite 100% must if you've got this kind of assets in your life.
yeah, and such a catalog of music, and Jerry co-wrote a lot of the music with a third party that was not a member of the band. I don't remember his name, but anyway, I actually didn't know that. I just made the assumption that Jerry was the primary writer on most of the songs, certainly Bob Weir, I'm sure, wrote some, but still, yeah. So but he still has these song rights to all these songs. And then there's the recording rights, meaning you also, as an artist, if you participate in a recording, then you're entitled to a royalty relating to that. So the recording piece is entirely separate from the composition piece.
A lot of pieces.
A lot of pieces, yeah. And then you get paid when it's played.
And those
So
residual checks come in every year,
it's
and
nice, but you got to have somebody following. I mean, ASCAP tries to do this. It's the organization that protects its members, songwriters and whatnot. So they try to police the payment of these things, and they do a reasonably good job. But we know on this show that there have been cases where families have missed out on $1 million plus in the case of Glenn Campbell.
yeah.
So anyway, I'm glad that Jerry did a will.
Yes, thank goodness.
If you had asked me, did Jerry Garcia have a will, I probably would have guessed no.
Well, I have a feeling that his daughters, his children, I think that he was a good dad and he
Yeah.
thought about them, and that's probably the biggest reason why there was a will. If it was just probably the wives, maybe not.
Yeah, yeah, and look, let's face it, the wife. Yeah, I'm sure that she was on top, and that doesn't make her, a money hungry spouse. A spouse has to think about that because sometimes the other spouse doesn't, especially when you know they're in bad health, et cetera. So these are kind of my comments overall regarding the estate plan here is one of the biggest problems was a failure to assure that there was adequate liquidity. And what I mean by that is some of the people could have been paid off. Some claims could have been easily settled. There's lots of things that can be done if you have some pool of cash in order to address it, not to mention that money is necessary to keep things going. And that, in many cases, a band is like a business. So to the extent that there were contributions required in order to keep things going just long enough to get through the probate process, just to keep things from deteriorating, cash is a helpful thing. Now, a rock band is not the best example of the need for liquidity, but we know in this case that there wasn't the funds to pay off some of these claims that could have been settled better than even they were. Now, it turns out that only by wearing down these claims over a period of time, ultimately it's amazing they get it down to $700,000.
Would that be something that if they wouldn't have been able to do that maybe they would have had to have gotten rid of some of the assets, like maybe his comic book collection or something like that, in order to pay off
And that's a
things?
good point. And I'm sure that did happen, meaning when you don't have liquidity in the estate, when you don't have a plan, life insurance would produce that. Jerry wouldn't be a candidate for life insurance
Probably not.
anytime in his last 10 years. But it's important to, whenever you develop a plan, when you do your estate planning, that you think, okay, there's going to be some expenses where cash will be needed. And it could be cash just to meet the needs of your family. But in this case, there was very little cash. And it was a cash crisis that they suffered in the short term. And they sold assets. We don't know what all they were, but I'm sure that the example you gave is probably one of them.
And that would be heartbreaking to know you had to sell some of your dad's stuff in order to take care of the other stuff,
And you have,
tough.
and not just sell it, but you have to take a discount. You get a haircut whenever you sell under those conditions. So that leaps out at me, number one here. And these aren't necessarily in order of priority because each of these is significant. The mistakes regarding the divorce settlement. Again, it ties in with this running theme in today's show where Jerry Garcia wasn't a planner. He was a little impetuous regarding anything relating to business. And I think that in this case, he just wanted to get this out from under him. He signs this document that was prepared by either his wife that were in divorce, or worse, her attorney. It doesn't look like a legal document. You can find copies of it online. But anyway, somebody prepared it in a way that it held up. And it was simple and to the point. So Jerry just signing that, apparently it was signed backstage at a concert.
Here, sign here.
Well,
right?
literally.
Before you get on
literally,
stage. Yeah.
she presented it to him and said, look, take care of, if you sign this, then I'm willing to settle. And, he just signs it. So that you could call that an estate planning mistake because, he was at a point in his life when he really needed to be thinking about, the remainder of his life as well as thereafter. And in his case, it should have been increasingly obvious that the thereafter was going to be a lot sooner than for many people his age. So I point to that because there's a $5 million issue that resulted in, I don't know how much was spent in legal fees, doubtlessly hundreds of thousands. Failure to set up a trust. I guess if I had to put these in order of largest failures, I guess failure to set up a trust. The trust would have insulated some of the assets better from these claims. And the trust also would have put in place the machinery for these assets, these complicated assets, intellectual property, to be managed over decades for the benefit of the family. And it would have headed off this conflict where they've tried to work together as a partnership, which they did for a while. And one of those efforts was this 5-year period of time, and they signed this agreement through the Jerry Garcia Family LLC. It was an effort to force them for 5 years to where they couldn't divorce from each other, so to speak. And it did. It held them together for 5 years, but then it splintered apart. So I think that a trust would have put in place professional management. It could have handled this in a way that would have been so much easier for the family. It's easier for us on the outside to look at 9 years of litigation and uncertainty and frustration and court appearances and hiring your own lawyers. Yeah. I mean, for us,
it's exhausting, I would imagine.
It's easy for us to be a little dismissive about that until you've lived it. And people who've lived it, and I'm sure some of you have your own stories to tell where you've been in similar situations. That was a huge toll on the family. It all could have been headed off. But again, it wasn't Jerry Garcia's nature. None of us, including his family, I'm sure were surprised that they were in this situation. But a trust would have been hugely beneficial. Inadequate attention to resolving pending claims, and this was during his lifetime. Most of us would be concerned that we had a lot of floating claims out there potentially that hadn't been settled. We know that there are people who are calling us periodically saying, you owe me this money, or maybe they're just sending a letter. I think Jerry was the sort that he ignored things as long as he could. And so there are a number of things that were in that inbox when he died.
Well, I figure he was also in, rehab.
Oh, yeah.
So maybe you couldn't get mail anyway there,
right.
I mean.
Which makes a larger statement. Yeah, he really just wasn't in control at the end. And so these things, this is not a list that's realistic to expect of Jerry probably, but it's realistic, I'll presume, to expect it of your loved ones and you. And that's that, leaving those claims out there when you're the best person often to offer testimony or to quash them. If they're frivolous, get rid of them while you're alive, because the evidence that you can mount to overcome those claims is likely to be much better than what can be mounted by your relatives when you're gone. So even though there are certain protections afforded the dead, a claim that comes forward, there's no one to make the argument for you. If there's a legal document or what appears to be, or an argument, sometimes it could be an oral claim for some things. Thankfully, you have rules of evidence that will limit victimization of people who are dead by oral testimony. Yeah. But still, you're in much better condition to resolve that when you're alive, and to resolve it at a better rate than when you're gone. Then the final item, I guess, that stands out here is it's kind of a general comment, but it seems to hover over the entire episode and the latter part of Jerry's life, if not all of his adult life, and that substance addiction, that really impacted everything. Everything.
Definitely.
I mean, we just going down this list. We're implicitly referring to the drug substance addiction.
Yeah.
So whatever Jerry's worst propensities were, they were doubtlessly magnified by his substance addiction. If you could have taken that off the table, Jerry would probably have been much more effective than he was. Doubtlessly, he'd be more effective than he was. And this is a hard one to solve for people. But I tend to impute to people responsibility and agency, and I tend to think that we have to ultimately be the captains of our ship. And to the extent that we start saying that the captains are not responsible for the ship, then that's not good for them or us, either one. So he was the captain of his ship, and there were some things he did that just were not good.
Yeah.
So that wraps up this discussion. So much more could be said about Jerry Garcia. He's a fascinating guy.
Yeah.
You can, if you want to be entertained, there's some long interviews with Jerry Garcia online, because he did a lot of interviews. Like you said, he said I had the answers. He said most of them weren't right, but he said I had answers.
He was a talker, so he was like, yeah, sure, yeah.
And the other interviews, I'm telling you, you'll be amazed how long you can sit and watch an interview by Jerry Garcia. You may be thinking, I can't watch anybody talk for an hour and a half. I'll bet you can watch Jerry Garcia talk for an hour and a half. He was really funny, and particularly in his earlier days. But you can find lots of those on YouTube. So I hope this has been fun as well as informative and helpful. So this has been another episode of Life's Third Act. Till next time, take care.
We hope you enjoyed Life's Third Act, sponsored by Cordell & Cordell, your advisors for estate planning and beyond. Subscribe and join us weekly for thought-provoking discussion and topics exclusively focused on estate planning and your financial future. Discover more at CordellCordell.com. The choice of a lawyer is an important decision and should not be based solely on advertisements.